Hello students, welcome you all for the course of MBA Semester 3 Human Relations and Legal Framework. Today is our session 29 and the topic of our today's discussion is Payment of Wages Act 1936 Part 2. So the primary objective of our today's session is help to understand some other important provisions in the Payment of Wages Act 1936. So the contents of our today's session are wage period for the payment of wages, deductions allowable from the wages, fines, maintenance of registers and records, penalties, and payments in case of death. So these contents that we are going to see in our today's session. So let us start the discussion. Wage period for the payment of wages. So as we were discussed in the last session about payment of wages and some earlier provisions in this Payment of Wages Act. Okay. So each and every employer has to make the payment of wages to the workers within some appropriate period of time. Okay. And that appropriate of period of time shall not exceed 1 month. Okay. On completion of every month, okay, all the workers are liable to get the wages. So generally on the 7th day, okay, or in some industries, okay, on 10th day of every month, okay, after completion the wage period, okay, the workers are liable to get the wages, okay, payment of wages, okay, on behalf of whatever labor that they were performed, okay, in the factory or whatever form of industrial establishment. So there are some prescribed conditions are there with respect to the wage period for the payment of wages. Okay. uh, all such workers, those are belonging to railway, factory or industrial and other establishment where 1000 persons are employed in the factory, okay, so they are liable to get the payment of wages, okay, before the expiry of 7th day after the last day of the wage period in respect of which the wages are applicable. Okay. So on every 7th day after completion of the wage period, okay, or after the last day of the wage period, the workers are liable to get the wages of workers. Okay, these conditions would be applied particularly to the industries, okay, wherever 1000 workers are less than 1000 workers are employed, okay, those are in railway, factory or industrial other industrial establishment. Apart from that, okay, some other industrial units, say for example railway, factory and industrial and other establishment wherever there are more than 1000 people are employed, okay, in that case, okay, on every 10th day after the last day of the wage period, okay, the wages of workers need to be paid. So these two basic conditions are being supposed to be there, and minimum time of some industrial establishment wherever more than 1000 workers are employed, so for which, okay, such workers they will liable to get their payment of wages, okay, on completion of the 10th day after the last day of the wage period. So in this way the wages of workers need to be paid by the workers, by that particular employer. Okay, here the person should be responsible for the payment of wages, okay, who will decide the wage period. It is the basic condition, okay, when eventually the payment of wages shall be defined by particular industrial uh, unit, okay, or factory. So the person, particularly the HR manager or the works manager, that they will decide the wage period, okay, and whatever form of wage period will be there, okay, that during that wage period only the payment of wages could be there. Now there are some other provisions specifically for some other industries. So workers, those who are employed on dock, wharf and jetty or in mines, okay. So in that case, how does the wages has been provided? The balance of wage found due on completion of the final tonnage account of the ship or wagon, loaded or unloaded as the case may be, shall be paid before the expiry of the seventh day from the day of such completion. Okay. Now on some industrial premises, say for example docks or mines, okay, or wharf or jetty, where workers are being allotted some particular form of work, okay, say for example loading of raw material or finished good either on the ships or some big vessels, okay. So from which date, okay, it has been allotted, okay, to its completion. So after the completion of seventh day, okay, the wages should be provided to all such workers, okay. So specifically to these dock workers, so after completion, after loading of or unloading of the raw material from the big ships or vessels, okay, after completion of that work, okay, so minimum 7 days period has been decided as a wage period, okay, and during the 7 day, okay, the wages need to be paid to these dock workers. Where the employment of any person is terminated or on behalf of the employer, the wages earned by him shall be paid before the expiry of the second working day from the day on which his employment is terminated. Okay. Now if suppose the employee is going to be terminated by an employer, so when does that he is going to complete, okay, that particular period of time, okay, and that particular period of time would be the wages earned by him shall be paid before the expiry of the second working day. So whenever that worker is going to be terminated, okay, so before the expiry of second working day, okay, that total emoluments means total wages need to be paid to that particular worker who is going to be terminated. But where the employment of sub person is establishment is terminated due to certain type of closure of the industrial establishment, particularly when the industry will close their operations, okay. So in that case, whatever wages that he will receive, okay, that should be paid before the expiry of second day from the day on which his employment is terminated, okay. So in this case also, in case of closure, okay, whatever form of total emolument of wages would be there, it should be given to the respective employee, okay, whenever he is going to complete his period, okay. So it should be paid before the second day of the expiry, okay, of that particular employee. Now deduction allowable under the wages, okay. So according to the that wages act, okay, that section 7, according to section 7, okay, that act will allow some particular form of deduction that should be deducted from the wages of the respective employee, okay. So what form of deductions will be considered as legal and what form of deductions will not be considered as legal? So let us see one by one. Fine, okay, that fines have been taken by the employer on account of some particular form of misconduct or loss or damages happened in the factory. Absence from the duty, so leave of absence, that in case the employee has not been applied. Damages to or loss of goods expressly entrusted to the employee, any form of damages, okay. Housing, accommodation, amenities provided by the employer, say for example HRA, okay. recovery of advances or adjustment of overpayment of wages. If any of the employer has made any overpayment of wages to the employee, in that case one can make a recovery. So recovery of loans made from fund constituted about the labor welfare fund. Okay, so in that case, okay, recovery of loans can be made. Any other form of subscription to or repayments of advances, particularly for any provident fund. So provident fund subscriptions can be taken by the employer. Okay, income tax. Okay, so income tax deductions would be there. So such kind of deductions are being permitted. Payment to any cooperatives if the employees were formed any cooperatives about generation of some particular fund. Okay, say for example state government or the state government scheme or any such schemes which has been related with the insurance maintained by Indian Post Office or any other organization. Okay, so uh, which has been permitted by the state government. Okay, uh, another form of deductions. Okay, deductions made with some written authorization of the employee. Okay, for the payment of any kind of premium, particularly for life insurance or any purchases of securities. So such kind of deductions which are being permitted under the Payment of Wages Act. Okay, 1936. So these section 7 deals with such kind of deductions which are being permitted. Now deductions which will not be directly permitted, okay, but they will be collected in the form of fines. Okay, so these fines are not directly called as the deduction. These are exclusively called as fines. Okay, so when does that fine will be imposed? Okay, on what account that fine will be imposed, and it should be taken from the respective employee. So the section 8 will deals with that fines. So different uh, on different account, okay, or on the different circumstances, the employer can recover this fine from the wages of the respective employee. Okay, and that should be imposed by the respective employer on the respective employee. Okay, due to some particular kind of acts or omissions. Okay, so let us see some important provisions over here. So no fine shall be imposed on any of the employed person, okay, save in respect of such acts and omission on the part of the employer with the previous approval of the state government, or may be prescribed by the authority according to notice under subsection 2. So no fine can be imposed by any of the on any of the employed person which has been permitted by the state government on any kind of acts or omissions which are being permitted. Okay, on his part of the employer. So in that case, okay, the employer could not collect the fines. There are some standard procedures has been laid down, okay, on which account the fine has been taken and on what matters the fine has not been taken. A notice of specifying such acts and omissions shall be exhibited in a prescribed manner on the premises. So what acts and omissions that may be related with the kind of misconducts or indiscipline which can be entertained or which cannot be entertained within the factory premises, that should be clearly mentioned in the factory premises or near the gate wherever the entry of the workers are happening. Okay, or in case of person employed upon the railway, okay, other than in factory, at the prescribed places. So all such acts and omissions has been appropriately displayed on the notice board. No fine shall be imposed on any of the employed person until he has been given an opportunity of showing the cause against the fine. Otherwise, in accordance with such procedure may be prescribed for the imposition of fines. Okay, so one cannot directly collect the fines from the employed, okay, from the employed person. Okay, for which whatever form of acts and omissions are being there, okay, that will mention the rules and regulation under the standing order or in the agreement. If the employer founds an opportunity that there will be a violation of rules and regulation, then in that case they can collect the fine, otherwise they could not collect any amount of fine. Total amount of fine which may be imposed in any wage period, okay, on that particular employed person, that should not be exceed an account equal to 3% of the wages, okay. So whatever will be the total emoluments of that respective employed person, so employer could not collect more than 3% of their wages as fines, okay. So that should be a the very important provisions, particularly how much amount of fine that the employer can impose on the employed person, okay, on account of any kind of misbehavior, misconduct or indiscipline or any form of loss which can be happen in the factory premises. Now, here there are some other conditions which are related with the fines. So, no fine shall be imposed on any employed person who is under the age of 15 years. So, underage employee, particularly employees those who are working, okay, less than 15 years, okay, there uh, they, okay, these workers could not be imposed, okay, any kind of fines over here. So any of the employer, they could not collect any kind of fines, okay, from these workers those are belonging to below the age of 15 years. No fine shall be imposed on any of the unemployed persons. Those shall be recovered from him by installments or after expiry of 90 days from the day on which it was imposed. Now whenever the fine has been imposed, okay, okay, that fine could not be recovered by means of using an installment. So in case of fine, there is no installment, one cannot take the fine by means of any form of installments, okay. And that fine should be collected, okay, within the 90 days, okay, from which the fine was imposed, okay, due to any kind of misconduct or acts or omissions of the employee, okay, employer can impose the fine, but that fine could not be collected in installment, and as well as within minimum 90 days the fine will be collected from the respective employee. Every fine should be deemed to be have been imposed on the day of the act or omission in respect of which it was imposed, okay. So whatever form of fine has been there, okay, that fine must be related with the acts and omissions of the activities that are being relating to the misbehavior, misconduct or indiscipline, okay. So that should be clearly mentioned. So every fine shall be deemed to have been imposed on the day of the act or emission. So on which day that particular act was happened, okay, on from that day the fine will be imposed on that particular employee due to his misbehavior. Now all such fines and realization thereof shall be recorded in the register, okay. It should be very clear from this act, payment of wages act 1936, okay, whatever fine has been imposed by the employer on account of any act or omissions by the respective employee, okay, that amount of fine should be registered, okay, under some particular record, okay, it should be registered under the record according to the wages act 1936 in section 3, okay, it has been mentioned. So all such realizations shall be applied only to the purpose of beneficial to the person employed in the factory or establishment, are as are approved or by the prescribed authority. So from whom that the fine would be collected, okay, that should be clearly mentioned in the register, and from whom the fine will be collected on account of any of the acts or omission that the employee has been conducted. So and the record of that fines would be mentioned, okay, in the factory. Now the maintenance of registers and records, okay. So once the payment of wages are happening in the factory, okay, according to section 13A all employer they should have to maintain one register, okay, and that register will cover the entire record of payment of wages, okay, in the given month, okay. So this will include the person employed by the employer, okay, what work that they were performed and how much amount of wages that they were paid, okay, to them, and any other form of deductions are supposed to be there. All such deductions should be mentioned in that register, and the receipt given by them and other particulars are mentioned in this register. So that register is nothing but the record of payment of wages to the workers, and that has been mentioned according to the section 13A of the industrial in all industrial establishment as well as factories according to the Payment of Wages Act 1936. And this every record and register shall have to be maintained by the respective employer for minimum of 3 years. So all employer they should have to keep the register, okay, and that register will containing the records, okay, of the payment of wages of all such individual employees along with the date of last entry which has been mentioned therein, okay. So whatever form of wages has been provided in all the respective months, okay, so what wages has been provided, is there any form of deductions or any other fines, okay, they were collected from the respective employee, okay, all such things has to be maintained particularly for 3 years, okay. So and this can be inspected, okay. There will be a factory inspector. That factory inspector should visit to the factory premises and ask for each and every details regarding the payment of wages, okay. So these are the provisions for the maintenance of registers and records. Now there are called as some penalties. Now that penalties will be imposed particularly on the employer on account of non-maintenance of registers and records for the payment of wages to the respective employee. When these penalties has been imposed, generally there will be a factory inspector would be there, and that factory inspector will conduct the inspection. If he suppose say found any kind of mischievous things particularly that is happening with the maintenance of registers, okay, relating to the payment of wages of the respective employee, okay, in that case, okay, the inspector can impose the penalty on the respective employer or the other principal employer those who are being employing the persons in their factories or other industrial establishment. So on what account, okay, that penalties will be imposed on the employer, okay. So here we will find that, okay, if the employer fail to maintain such registers and record, in that case penalty would be there. He willfully refuses or without lawful excuse or neglect to furnish the information to the inspector, okay. Here the employer that they will refuse to show the record, in that case willfully furnish or cause of furnish any other information relating to the payment of wages or any false information if the employer are being presenting before the inspector. If he suppose refuses to answer willfully, okay, in that case also, okay, so there will be 3-4 conditions are here. If any of the act, okay, which has been happen on account of the employer, okay, there will be a penalty, and that penalty would be there, okay. This is called as the offense, okay, and that offense would be punishable with fine, okay, and that fine should not be less than rupees 1500, okay, and which can be extended up to 7500. So if any of the employer they are not maintaining their registers and willfully doing any some wrong acts by misrepresenting the information to the factory inspector, in that case factory inspector can impose the penalty on the employer, and that penalty would not be less than rupees 1500, and that may goes up to 7500. Now this again some different form of provisions by the factory inspector whenever they will inspect the factory premises, and they will investigate the maintenance of registered. Okay, so willfully obstruct an inspector in the discharge of his duties or under the act. If any of the employer, they will obstruct and disturb the inspector to investigate the issue and discharging his duties. Okay, and he will be, the employer will be disturbing these factory inspector in their day to day operations. Okay, rather than cooperating to show the payment of wages registered to them. In that case, they can impose the penalty on them. They refuses to willfully neglect or to afford the inspector in reasonable facility for making any entry, inspection, examination, supervision, inquiry authorized by the rule. If they, in case of factory act, there are different provisions which are being related with the factory inspector. Okay, and that may be related with that a inspector can identify the reasonable records from the registered. They can inspect, they can examine, supervise, or they can conduct an inquiry at even plant level also. If the employers are not cooperating, in that case, okay, the factory inspector can impose the penalty on them. Willfully refuses to produce the demand of the inspector any register or any other documents kept in pursuance of the act. According to act, okay, whatever provisions has been there, if any document or any other registers, okay, which are explaining the payment of wages and other deductions or fines, okay, which are being not produced by the employer, okay, whenever the factory inspector visited to the factory, in that case also there is a fine. Okay, and there will be a penalty to the employer. And prevents and attempts to prevent or does not anything which he may reason to believe likely to prevent any person from appearing before any examined by the inspector acting in pursuance of his duties under the act. If the employer, those who are being not allowing to make allowing to interact with the respective employee, okay, or to investigate the issue with the respective employee, okay, so as to find the appropriate reason from that respective employee. Okay, here again the factory inspector can implement some sort of penalties on the respective employers. Now in this case also it is generally these provisions are being related with the means disturbing the act of the factory inspector to investigate the issue regarding the payment of wages, deductions, and related fine related activities. If it has been imposed, the employer need to maintain all such details. Okay, if any of the offense that has been happening in this sense, okay, the act shall be punishable. Okay, and the penalty would be there. Okay, and that penalty should not be less than 1500 rupees, and which cannot be extended to 7500 rupees. So even in these cases also there will be a penalty. Now there are some particular forms of penalties, okay, that should be implemented on the account of the acts, okay, by the employer, and that should be imposed on the employer. If any person who has been convicted any kind of offenses punishable under the act, say for example any kind of fraud which are being related with wages or maintenance of registers appropriately, okay, so in that case also the factory inspector can investigate the issue, and there will be a possibility of imprisonment. Okay, and that imprisonment would be not less than 1 month, or that may be extended to 6 months, along with some fine. Okay, and that fine would not be less than 3750, but may be extended to 22500. So on account of any of the offenses, okay, if the employer has been committed, okay, that such kind of offenses or any kind of fraud which are relating with the wages, okay, that are also punishable, and there will be a penalty, okay, penalty of 3750 that may be extended with 22,500 along with some sort of imprisonment. If any person fails to willfully neglect to pay the wages of any employed person by the date fixed by the authority, okay, in that behalf, he shall without prejudice to any other action that may be taken against them should be punishable with the additional fine which may be extended to rupees 750 on each day, okay, for which the failure or neglect continues. Now suppose the wage period has been defined, okay, that wage period may be 7 days or up to 10 days in some different industrial establishment or the factories. If the wages could not be happen within the 7 days or 10 days, okay, then in that case also the penalty would be there, okay, and that penalty would be 700 rupees each day, okay, could be imposed on the employer, okay, and this act has been punishable with some additional fine. So in this way the penalties has been imposed on the respective employer for non-performance of activities which are being related with the Payment of Wages Act 1936. Now this is the special case which are being related with the payment in case of death of the employee, okay. If the person has been died, okay, so the employer could not directly make the payment of wages to the respective bank account of that particular deceased employee. So there is a provision, okay, in case of death of the employee, okay, if the person has been died, his remaining monthly wages, okay, will be deposited to the nominee, okay, it will be paid to the nominee, okay, or where such nomination has been made, where any reason such amount cannot be aid to the person nominated be deposited with the prescribed authority, okay, or in case the nominee has not been directed by the deceased person to whom exactly the remaining wages would be deposited, okay, the prescribed authority will decide, and that remaining amount with respect to the payment of wages of the deceased employee will be paid to that particular person. So in this way the payment in case of death of that particular employee, that death may be occur due to accident, okay, permanent or partial disablement, okay, or due to occupational diseases, any of the things that are being matter that has been connected with it. So if the workers those are being entitled to get the wages, they need to pay these wages regularly, and all these provisions are being there in the Payment of Wages Act 1936, okay, that should be followed by the employer and need to pay these wages regularly to the employees. So that's all for our today's session. Thank you very much.